Imagine this scenario. It's 3:00 a.m. on a Tuesday. You are a cloud architect, or maybe you're a GRC analyst working for a major European enterprise. And you've done everything right, or at least, you think you have. You've migrated all your sensitive customer databases. We're talking healthcare records, maybe financial transaction logs straight to the cloud. But you were really careful about it. You specifically selected the sovereign cloud region. You picked Frankfurt, Germany, or maybe Paris. You have this dashboard on your screen that glows green, assuring you that your data is resident completely within the European Union. You sleep soundly, thinking you're entirely safe from foreign subpoenas, specifically those from the United States. And then
Then the phone rings, and it is not your boss.
right, it's your cloud provider's legal team. A warrant has arrived, not at your office in Berlin, but at your cloud provider's headquarters in Seattle, Washington. The U.S. Department of Justice wants that data sitting in your quote-unquote secure Frankfurt region. And your provider, they're telling you they basically have no choice but to open the doors.
It is the absolute nightmare scenario for anyone in our field. And I have to drop the hard truth right at the start here. Your data residency, that beautiful dashboard showing Frankfurt, it means absolutely nothing to the U.S. Department of Justice. Zero. We are talking about the collision of two massive legal frameworks today: the General Data Protection Regulation, GDPR, and the U.S. Cloud Act. And standing right in the middle, trying to protect you, is a blocking statute known as GDPR Article 48. But as we're going to find out through the research today, that shield might just be made of wet paper.
Welcome to InfoSec Bytes, your go-to podcast for bite-sized insights on information security, AI, cloud, quantum, and cybersecurity incident root cause analysis. With over 100 episodes, we've got you covered on the latest trends and tips. This year, we will focus more on cloud computing along with other topics, so stay tuned. Please like, subscribe, and share to join the conversation on various platforms: Spotify, Apple Podcasts, YouTube, Amazon Music, and stay secure.
It's great to be back. And frankly, I am incredibly excited about this deep dive. We aren't just talking high-level policy today. We are dissecting the brand new research, specifically the EDPB guidelines 022024, the complex five-step fine calculation methodology that literally scares the living daylights out of CFOs everywhere, and the technical reality of what possession, custody, or control actually means in a distributed system.
And just a quick reminder to all our listeners out there, while we are analyzing regulations today, and we're definitely going to get deep into the weeds of legal text, this is technical research and security analysis. It is not legal advice. Please, for the love of everything holy, consult your actual legal counsel before you go telling the DOJ no.
Absolutely. Do not use this audio as a defense in federal court. That will not end well for you.
So let's start right at the foundation. Before we get into the cage match between the US and the EU, we really need to understand the why. Why is the European Union so aggressive about this? Because it feels like every single week there is a new headline about data sovereignty. It's not just bureaucratic flexing, is it? It runs a lot deeper.
It does. It really does. To understand the conflict, you have to understand the ethical scaffolding of the GDPR. It is not just a list of compliance rules, it's a fundamental philosophy about human rights. It is built on 7 key principles found in Article 5. If you violate these, you aren't just breaking a minor rule, you are undermining the entire European legal system. And for a cloud architect listening right now, these aren't abstract concepts. These are literal design constraints for your architecture.
Let's walk through these, but let's look at them through the lens of someone actually building a system. I know the first one is lawfulness, fairness, and transparency.
Right. This is the bedrock. You absolutely must have a legal basis to process data, and you cannot trick people. In the context of our deep dive today, lawfulness is the trap. If you hand data to a foreign government without a legal basis in EU law, you have failed the very first principle. You're building your whole house on quicksand.
Then we have purpose limitation, which basically means you can only use data for what you said you would use it for.
Exactly. If you collected data to, say, process payroll, and then you just hand it over to the FBI for national security investigations, you have violated purpose limitation. You use the data for a purpose entirely incompatible with the original collection.
The third one is a really big one for our data engineers. Data minimization. Don't hoard data.
Which is literally the exact opposite of how the modern cloud works.
Right.
I mean, every data lake, every AI training set being built right now is based on this idea of ingest everything, figure out the value later. But GDPR says no. Only keep what you strictly functionally need. If you hoard data you don't need, and then that massive pile of data gets subpoenaed, you have essentially created your own massive liability.
Yeah, you built the bomb that just went off in your data center. Then there's accuracy, keep it correct. And storage limitation don't keep it forever.
Right. Again, massive friction with the infinite cheap storage mindset of the public cloud.
Number 6 is integrity and confidentiality. This is Article 32.
Yeah, the security requirement, encryption, access controls, IAM roles. This is usually where we as security professionals feel the most comfortable. We know how to configure a firewall, we know how to rotate keys. But the seventh one, that is the absolute game changer. Accountability.
I really want to double click on accountability because we see this word a lot in the research we reviewed for today. It sounds like corporate buzzword bingo, honestly. But under GDPR, it has a very specific, very sharp bite to it. It's not just about being responsible, is it?
No, it's much more aggressive than that. In the old days of InfoSec, compliance was just check the box. You have a firewall? Check. Do you have an acceptable use policy? Check.
Yeah.
Accountability shifts that entirely to a risk-based approach. It means you are responsible for actively demonstrating compliance. It is not enough to just be secure. You must mathematically and documentarily prove it.
So the burden of proof is totally reversed.
Entirely reversed. If a regulator walks into your office, you are basically guilty until you prove you are innocent. This involves massive documentation, audits, and data protection impact assessments (DPIAs). If you cannot produce the paper trail showing exactly why you made an architectural decision, you are already non-compliant, even if absolutely no data was ever lost or breached.
And this ties directly into the roles people play in the cloud, right? We have this dynamic of the controller and the processor. In the cloud world, this gets so messy so fast. The research uses an analogy about a brewery, but I feel like we need to make that a bit grittier and more relevant for the cloud era.
Let's do it. So imagine a brewery. They decide they want to pay their employees. They determine the why we need to pay our people and the how we are going to use direct bank transfers. The brewery is the controller. They're the ultimate boss of the data. Now, they hire a payroll company SaaS platform to actually cut the checks and run the software. The payroll company takes the data and processes it. They are the processor.
Okay, simple enough so far. The brewery is the end customer. The payroll company is the sauce provider.
Right. But let's complicate it, because the real world is incredibly messy. The payroll company does not own their own physical data centers. Nobody does anymore. They rent compute and storage space from a massive hyperscaler. Let's call them mega cloud. Who is mega cloud in this legal equation?
They would be a sub-processor, right, underneath the sauce company.
Exactly. Mega cloud is a processor for the payroll company. But here is the massive kicker. Under Article 28 of the GDPR, there must be a binding, legally enforceable contract all the way down that chain. If the brewery did not explicitly authorize MegaCloud as a sub-processor in their initial contract, the payroll company is already in breach of the law just by using them.
And if MegaCloud gets a warrant from the DOJ, they don't even know who the brewery is, do they?
Precisely. MegaCloud just sees encrypted blobs of data belonging to tenant ID 456, which is the payroll company. The DOJ serves the warrant directly to MegaCloud. MegaCloud hands over the data to comply with U.S. federal law. The payroll company might not even know it happened because of a gag order. And the brewery, the actual controller, they're completely in the dark until the massive GDPR fine arrives in their mailbox.
That is the chain of accountability snapping right there in real time. If the processor or the sub-processor, like MegaCloud, acts outside of their explicit instructions, like handing data over to the FBI without permission, what actually happens to their legal status?
This is a fascinating part of the research. Legally, if a processor acts outside of the controller's documented instructions, they arguably become a controller themselves for that specific processing activity. They assume full, unfiltered liability. They are no longer just a service provider following orders. They are now the primary decision maker, and they just made a decision that fundamentally violates European law.
If you are a GRC analyst listening to this right now, I know you know the pain of chasing these Article 28 contracts. You spend months negotiating data processing addendums. But the really big question we are tackling today is, does that piece of paper, that contract, actually save you when the FBI comes knocking with a federal warrant?
And the short, terrifying answer is probably not. Because now we have to introduce the main antagonist of our story, the U.S. Cloud Act.
Okay, let's bring in the challenger. The Cloud Act, it sounds so fluffy and nice. Clarifying lawful overseas use of data sounds incredibly helpful, but in the research we've looked at, it is described much more like a massive jurisdictional vacuum cleaner for data. What is the actual origin story here?
The Cloud Act, which was passed in 2018, was a direct, aggressive response to a very specific court case, Microsoft Ireland. Long story short, the U.S. government wanted emails that were stored in a physical Microsoft data center in Dublin, Ireland. This was regarding a domestic drug trafficking case. Microsoft looked at the warrant and said, no, that data is in Ireland. We are a U.S. company, yes, but the data is physically resting on Irish soil. You need to go get a warrant from an Irish judge using international treaties.
Which honestly makes perfect sense in the physical world. If the NYPD wants evidence located in an apartment in London, they call Scotland Yard. They don't fly a SWAT team to London and kick down the door themselves.
Exactly. Microsoft was arguing for the traditional, centuries-old respect of sovereign borders. But the U.S. government said, no, you are Microsoft. You are a United States corporation. You have the administrative keys. We do not care where the physical hard drive is located. The case escalated all the way up to the U.S. Supreme Court. But before the Supreme Court could actually issue a ruling, Congress swooped in and passed the Cloud Act.
Which basically mooted the entire Supreme Court case and just codified the government's extremely broad position into law.
It established a terrifying new legal standard for cloud computing. Jurisdiction by control, not geography.
That is a massive paradigm shift. So the physical location of the server, the whole concept of data residency, is completely irrelevant.
Completely irrelevant to the U.S. Department of Justice. The research we reviewed uses the really great analogy of a virtual cabinet. In the old days, if law enforcement wanted your files, they got a warrant for a physical metal file cabinet sitting in an office in New York. If that cabinet was moved onto a plane and flown to London, the New York warrant was legally useless. They had to go to London. But in the cloud era, the Cloud Act says we don't care if the virtual cabinet is in Dublin or Frankfurt or literally on the moon. If you, the U.S. company, have the cryptographic or administrative key to open that cabinet, you must open it and give us the contents. This is the legal concept of possession, custody, or control.
Possession, custody, or control. That sounds completely all-encompassing. But let's get really technical for our listeners. Who does this actually apply to? Is it just the big three U.S. hyperscalers?
It applies to any electronic communication service or remote computing service that is subject to U.S. jurisdiction. That clearly obviously covers Amazon, Microsoft, and Google. But here's the massive nuance from the research that truly scares people. It applies if there is any kind of U.S. nexus.
A U.S. nexus. We definitely need to dig into that.
Oh.
Because a lot of our listeners are out there right now using AWS Europe or Google Ireland. They think, well, my contract is explicitly with a European legal entity, so I am safely insulated from the U.S. DOJ.
That is without a doubt the most common misconception in cloud architecture today. Let's play out a very standard technical scenario. You're a German manufacturing company. You sign a cloud contract with hyperscaler Europe Sarl, which is a registered Luxembourg company. You think you are totally insulated from the United States. But how does their technical support model work?
Well, usually it's a follow-the-sun model. If something breaks at 3:00 a.m. local time, someone in a totally different time zone picks up the ticket to keep the SLA.
Exactly. So your critical database in Frankfurt suddenly glitches. You open a 711 emergency ticket. It's 3:00 a.m. in Germany, so the automated system routes that ticket to a specialized Tier 3 database engineer sitting in Seattle. That engineer logs in, uses their credentials to check the logs, maybe run some queries to debug the underlying infrastructure issue.
Oh boy, I see exactly where this is going.
In that exact moment, a U.S. person sitting on U.S. soil has administrative visibility into your supposedly sovereign European environment. That is a U.S. nexus. Boom. The DOJ can immediately argue that the U.S. parent company has control, meaning the technical ability to access, retrieve, or decrypt the data. The fact that your piece of paper contract is with a Luxembourg entity does not matter at all if the actual technical control rolls up to the United States.
So even my basic 24/7 support contract could be the Trojan horse that breaks my compliance.
Absolutely it could. If the administrative credentials can be used from a laptop in Seattle, the data is subject to Seattle's laws.
So data residency, that warm, fuzzy idea that my data is in Frankfurt so I am safe, is effectively a total lie.
It is a brilliant marketing term. It is excellent for reducing network latency. It is great for feeling good during a board meeting. But as a legal shield against the Cloud Act, it is completely non-existent. If the admin credentials or the encryption keys are accessible by the U.S. parent, the Cloud Act absolutely applies, period.
This is genuinely terrifying for anyone relying on sovereignty as a security control. But the EU didn't just take this lying down, right? I mean, they wrote the GDPR before the Cloud Act existed, but they clearly anticipated this exact kind of extraterritorial overreach. Enter Article 48.
Yes, the infamous blocking statute. Article 48 of the GDPR. It's literally titled, Transfers or Disclosures Not Authorized by Union Law. It was specifically surgically designed to stop foreign governments from reaching across the ocean into the EU and grabbing data without asking permission first.
How does it actually work in practice?
The rule is remarkably simple on paper. A foreign court order, like a Cloud Act warrant from a judge in Virginia, is entirely unenforceable within the European Union unless it is based on an official international agreement. Usually that means a mutual legal assistance treaty or an MLAT.
Okay, let me make sure I have this straight. So normally, if the FBI is investigating someone and they want data located in France, they have to call the French police or the French Ministry of Justice. They use the MLAT treaty, and then a French judge issues a French warrant to get the data.
Correct. That is the respectful, diplomatic, treaty-based way of doing international law enforcement. It protects the fundamental rights of the European citizen because a European judge actually reviews the request against European law. But the Cloud Act was built specifically and explicitly to bypass the MLAT process entirely, because the MLAT process is slow, it takes months, sometimes it takes years to get a response, and the DOJ wants that data right now.
So we have a direct high-speed collision here. The Cloud Act says, give us the data right now, ignore the slow treaty. GDPR Article 48 says do not give them the data under any circumstances unless you use the slow treaty.
Precisely. It is the ultimate catch-22 for the modern cloud provider. Let's look at their options. Option A, they comply with the U.S. warrant. They hand over the data to the FBI. They have now just blatantly breached GDPR Article 48 because they conducted an unlawful international transfer. They now face a fine of up to 4% of their global turnover from European regulators.
Ouch. Okay, what about the other path? Option B.
Option B, they refuse the U.S. warrant. They tell the DOJ, GDPR says no. Now they face contempt of court sanctions, massive daily fines, and potentially even jail time for executives in the United States.
Rock meet hard place. You are breaking a major law no matter what you do. But wait, I was reading through the research, specifically the very detailed analysis by Peter Swire, who is a huge, highly respected name in privacy law. There is this specific phrase in Article 48 that lawyers just endlessly fight about. It says the prohibition is, quote, without prejudice to other grounds for transfer pursuant to this chapter, unquote. That sounds incredibly like a legal loophole to me.
Yes. The without prejudice loophole. This is the subject of intense, ongoing legal warfare. Let's argue this out so the listeners can hear both sides. Imagine I'm the general counsel for a massive cloud provider. I see that exact phrase without prejudice to other grounds. To me, that reads like a built-in safety valve. It says, okay, the foreign warrant itself isn't a valid legal pass to move the data, but if I already have another valid ticket to ride like standard contractual clauses or SCCs, I can still legally move the data.
So you're basically saying the warrant isn't the bus ticket. But if my company already has a monthly bus pass, which is the SECs we use for our normal everyday business operations, I can just use that existing bus pass to put the data on the bus and hand it to the FBI once it arrives in the U.S.
Exactly. Peter Swire argues that if a U.S. parent company routinely moves data to the United States for standard processing under valid SCCs anyway, why can't they just lawfully hand that data to the FBI once it's legally sitting on U.S. soil? Or use those existing SCCs to technically justify the transfer required for the warrant.
It's a really compelling argument if your main goal is just to keep international business moving without executives going to jail. But the European Data Protection Board, the EDPB, they absolutely hate that argument, don't they?
They despise it. They view it as a gross violation of the entire spirit of the European law.
Why, though? If the transfer mechanism, the SEC, is legally valid, why does the ultimate destination or purpose matter so much?
Because the EDPB strictly looks at the intent and the safeguards attached to the data. SECs are specifically designed for commercial data flows, sending data to the U.S. to be processed for customer billing or marketing analytics or just cloud storage. They include civil safeguards. They are absolutely not designed for covert law enforcement access. The EDPB argues that you cannot simply hijack a commercial transfer tool to justify a law enforcement disclosure that explicitly bypasses judicial due process. It is exactly like using a standard building permit to legally justify a break-in. Just because you have the paperwork to be inside the building during the day does not mean you can loot the place at night.
That is an incredibly strong counterargument. You can't use a building permit to justify a break-in. That makes a lot of sense.
And this brings us right to the new playbook.
Yeah.
Because this debate isn't just theoretical academic arguing anymore. The EDPB just recently dropped Guidelines 022024. This is the absolute most critical part of this deep dive for our auditors and architects listening right now. What does the EDPB definitively say we have to do?
These new guidelines are basically the strict game plan going forward. They focus specifically on direct requests from third country authorities to private entities. So when the FBI calls AWS directly, or when they call you, the enterprise customer, directly, the EDPB lays out what they call a two-step test.
2 steps.
Mhm.
Sounds simple enough on the surface. What is step one?
Step one is that you absolutely must have a legal basis under GDPR Article 6. You cannot process data, and legally, handing it over to a government is considered processing without a defined legal basis.
Okay, let's look at the standard options in Article 6. Usually in these situations, companies try to use legal obligation, which is Article 6(1)(c). They say, I have to do this because the law says so.
But here's the massive trap the EDPB sets. Article 6(1)(c) only applies to EU or member state laws. A United States warrant is not a legal obligation under the GDPR. It's a foreign obligation. So you legally cannot use legal obligation as your excuse to hand over the data.
Okay, that one is completely thrown out. What about legitimate interest? Article 6(1)(f). This is the big one everyone tries to use as a fallback. Can a cloud provider simply say, my legitimate interest is that I really do not want my CEO to go to an American prison, or I don't want to pay massive American contempt fines? I have a fundamental legitimate interest in the financial survival of my business.
That is definitely the most common corporate argument. I have a legitimate interest in staying in business. But the EDPB ruling is generally a very hard no. They require a strict balancing test. On one side of the scale, you have the company's commercial interest in avoiding a U.S. fine. On the other side of the scale, you have the fundamental privacy and human rights of the European citizen.
And let me guess, under EU law, the fundamental human rights win that balancing act.
Almost every single time. The EDPB is essentially saying that the fundamental rights of the data subject completely override the commercial or legal interests of the company. They are basically telling these tech giants it is not the European citizen's problem that you chose to operate your business in a jurisdiction with conflicting laws. You cannot trade their fundamental rights just to ensure your own corporate safety.
Wow. So if a major U.S. cloud provider hands over a German citizen's data just to save themselves from a U.S. federal judge, they're effectively throwing that EU citizen completely under the bus. And the EDPB says you absolutely cannot do that.
Exactly. And under Article 48, without passing that step one legal basis, the entire transfer is immediately unlawful.
Okay, so step one is already a complete nightmare for compliance teams.
Yeah.
What on earth is step two?
Step 2 is complying with Chapter 5, which dictates the strict rules for international transfer tools. Even if you somehow miraculously found a valid legal basis in Step 1, which is incredibly hard, you still need a valid transfer tool. And here, desperate companies start looking at the derogations found in Article 49. Can we use public interest? Can we use defensive legal claims?
Defensive legal claims sounds somewhat promising, like, I need to transfer this data to the U.S. to defend myself against a contempt charge in a U.S. federal court.
It is technically possible in extremely narrow cases, but the restriction is incredibly strict. The research shows these derogations are exclusively for occasional, non-repetitive transfers. You absolutely cannot build a standard business process or an automated legal response pipeline on them. If you are a hyperscale cloud provider receiving thousands and thousands of law enforcement requests every single year, you legally cannot rely on a derogation that is explicitly designed for a one-off, occasional use case. It completely breaks the architectural intent of the law.
So this two-step test isn't really a pathway to compliance at all. It's basically an aggressive filter designed so that almost zero requests can actually pass through it. The guidelines are effectively reinforcing the stance that any direct cooperation with foreign law enforcement, if it bypasses the MLAT treaty process, is almost always going to be a severe GDPR violation.
Exactly. Which means we really need to talk about the consequences of failing this test. We always hear that scary phrase in the industry, 4% of global turnover. It's the ultimate boogeyman number that vendors use to sell compliance tools. But how is that massive fine actually calculated in reality? Is there just a regulator in Brussels throwing darts at a dartboard?
Thankfully, no, it is not random at all. The research points us directly to the EDPB Guideline 042022 on the calculation of administrative fines. It is a very structured, rigorous, five-step mathematical methodology, and I honestly think we need to actually run the math here live on the show to show our listeners why this is so terrifying for the C-suite.
Let's do it. Let's invent a completely hypothetical company. We'll call them Cloud Corp.
Okay, I like it. Cloud Corp is a massive SaaS provider headquartered in California. Let's say they have a global annual turnover of exactly $10 billion.
Yeah.
But they operate a small regional subsidiary in Dublin, Ireland. Let's call it Cloud Corp Ireland, which only generates about $50 million a year in local revenue. Cloud Corp gets hit with a massive Article 48 violation because the U.S. parent company bypassed the Irish subsidiary and handed EU data directly to the FBI under a Cloud Act warrant.
Okay, let's run the math. Step 1 of the guidelines. Identify the processing operations. They apply the one-stop shop principle.
Right, so the Irish Data Protection Commission becomes the lead supervisory authority handling the case. But here is the literal $10 billion question. Which turnover figure does the Irish regulator use to calculate the penalty? Do they use the $50 million Irish revenue or the $10 billion global consolidated revenue?
Well, logic would suggest the Irish revenue, right? I mean, it was the Irish entity that was technically responsible for the European data under the contract.
And that is exactly where you would be devastatingly wrong. The EDPB looks at the economic undertaking as a whole. They're not just looking at the Dublin office's petty cash or local spreadsheets. They're looking at the global consolidated revenue of the entire corporate parent structure. So for Cloud Corp, the starting point for this fine isn't based on $50 million. It is based on $10 billion.
Wow. So a 4% fine isn't just a slap on the wrist for the local European GM. It is a massive, immediate board-level crisis.
Exactly. It threatens the stock price. Step 2 is setting the starting point of the fine. They classify the specific infringement. Under the guidelines, violations are split into 2 categories, Tier 1 and Tier 2. Tier 1 is the lower level, usually capped at 2%. Tier 2 is the absolute maximum, up to 4%.
And where exactly does an Article 48 unlawful transfer violation fall?
Unlawful transfer of data is strictly, non-negotiably Tier 2. You're immediately starting the calculation in the highest possible bracket. Then the regulator assesses the seriousness of the breach, low, medium, or high. And this is the truly scary part. They apply a turnover adjustment.
What exactly does turnover adjustment mean in this context?
It means the fine mathematically scales with the absolute size of the company. The European guidelines explicitly say the fine must be effective, proportionate, and dissuasive. A €100,000 fine means literally nothing to a $10 billion company. It's less than a rounding error. It's the catering budget. So the math dictates that the larger the company's global footprint, the higher the base multiplier goes, just to ensure it inflicts actual financial pain. It is mathematically engineered pain distribution.
That is brutal. Okay, so step 3 is aggravating and mitigating factors.
Right, this is your behavior score. Did you cooperate with the regulator? Did you self-report the breach? Or was it an intentional cover-up? Did you try to hide the transfer from the customer? This can either lower the fine slightly or push it right up against that 4% ceiling.
Skipping to the end, step 5 is the effectiveness check.
This is the final sanity check by the regulator. They look at the final calculated number and ask themselves one question. Is this fine genuinely dissuasive? If the calculated number still just looks like a standard cost of doing business to a tech giant, the regulator has the authority to arbitrarily bump it up higher, solely to make a point and force a change in corporate behavior.
That is immense power. Is this fine dissuasive? I mean, imagine being a CISO and having to explain to your board of directors that you owe hundreds of millions of dollars, 4% of global revenue, specifically because you complied with a valid U.S. federal warrant, and the European regulator bumped up the fine just to make sure you felt it.
It puts the C-suite in a truly impossible, terrible position. Strict compliance with one major global power, the U.S. absolutely guarantees massive financial punishment by another major global power, and the EU. It is a no-win scenario.
We have painted a pretty bleak picture here today. Complete legal deadlock, huge business-ending fines, catch-22s everywhere. If I'm a cloud architect listening to this right now on my commute, I'm probably sweating. What can they actually do? Because we have to move from relying on legal paper shields to building actual technical shields.
Exactly. Paper shields, your DPAs, your contracts, your corporate policies, they're actively failing under the pressure of the Cloud Act. We desperately need technical shields. And the research we reviewed emphasizes one thing above absolutely everything else: encryption.
But not just any encryption, right? Because literally every cloud provider on Earth says, we encrypt your data at rest and in transit. That's just table stakes in 2026.
Correct. Standard cloud encryption usually means the provider is managing the cryptographic keys. This is often called platform-managed keys. If Amazon or Microsoft or Google physically holds the key in their key management service and the DOJ serves them a Cloud Act warrant, they possess the technical ability to decrypt that data. Therefore, under the Cloud Act, because they have control, they absolutely must decrypt the data and hand it over in plain text. So standard AES 256 cloud encryption is completely useless against the Cloud Act. Against the Cloud Act, yes, it protects you from a hacker stealing a hard drive, but it does absolutely nothing against a federal subpoena. The only real technical solution the research points to is BO, bring your own key, or much more accurately and securely, HYOK, hold your own key.
Hold your own key. Let's define the architecture on that.
This is strict client-side encryption. This is where the customer, the European enterprise entity, retains exclusive control of the cryptographic keys. You generate and hold the keys locally, perhaps in a physical hardware security module and HSM that is physically bolted into a rack in Europe. The massive cloud provider never, ever sees the unencrypted keys. They just store vast amounts of encrypted gibberish.
So if the DOJ serves a Cloud Act warrant directly to the hyperscaler, the provider simply says, here is the data you asked for, but it is mathematically encrypted, and we literally do not possess the keys to read it. Go ask our customer in Germany.
Exactly. It completely forces the DOJ's hand. They have to go to the customer, the actual control of the data. And if that customer is a German company sitting on European soil, the DOJ is forced to use the EMA treaty process or international diplomacy. It entirely breaks the virtual cabinet loophole because the U.S. provider physically does not have the key to open the cabinet.
That honestly sounds like the silver bullet we've been looking for. If it solves the problem so perfectly, why isn't every single enterprise doing it by default?
Because of the massive, massive trade-off, it is an absolutely brutal usability hit.
Okay, let's be real for a second. I am a cloud architect. I did not spend millions of dollars migrating my enterprise to the cloud just to use it as a dumb, expensive hard drive. If I use hold your own key, I break search functionality, I break server-side indexing, I break all those fancy generative AI features that my CEO is currently screaming at me to implement. You're telling me the only real solution to Article 48 is to completely blind the cloud and turn my state-of-the-art environment into a 1990s FTP server?
That is the brutal architectural trade-off.
Get it?
You are absolutely right. If you cryptographically blind the cloud provider, you lose all the magic of the cloud. The cloud provider cannot process, analyze, or train models on data that it cannot mathematically read. So you lose the AI capabilities, you lose Elasticsearch, you lose simple everyday functions like filtering a massive database by a specific date range because the database engine can't read the dates.
So you essentially have to make a boardroom decision. Do I want cutting-edge AI features, or do I want guaranteed immunity from the U.S. Cloud Act?
That is, without a doubt, the architectural decision of the decade for European companies. You have to aggressively categorize your data. You have to ask, is this specific data set radioactive? If this data is revealed to a foreign government, does the company die? Does it cause massive harm to citizens? If yes, maybe a secure FTP server or a strict HYOK vault is exactly what you need. But if it's just the corporate cafeteria menus or public marketing assets, you use the standard cloud and accept the minimal risk.
What about all these sovereign cloud offerings we are seeing now? I mean, the marketing ads are absolutely everywhere. Microsoft Cloud for Sovereignty, Google Distributed Cloud. Are these actual technical solutions or just more marketing fluff?
You really have to scrutinize the underlying architecture of these offerings very closely. Some of them are just data boundary marketing, meaning they just promise to keep the data stored in a specific European region. But we already established that fails the Cloud Act test immediately due to the U.S. Nexus issue with support staff. Others, however, are much more robust. If you are shopping for this, you need to look for the trustee model.
The trustee model. How does that differ from a normal region?
This is a setup where a completely separate, fully European legal entity controls the physical data centers and all the administrative access. The U.S. parent company provides the software updates, but they have zero direct administrative access to the physical server boxes or the customer data. T-Systems in Germany actually used to do a version of this with Microsoft years ago. If there is a provable, audited legal and technical air gap preventing U.S. support from logging in, that significantly helps mitigate the Cloud Act risk.
And we also have the new EU Data Act coming into force in 2025. That is expanding this protection even further, isn't it?
It absolutely is. The Data Act is huge because it extends these exact same blocking protections to non-personal data. Things like industrial trade secrets, proprietary manufacturing data, raw IoT sensor data. It legally mandates that cloud providers must take all reasonable technical measures to prevent the transfer of this data to foreign governments. It effectively codifies the entire Anti-Cloud Act stance into law for all corporate data, not just personal privacy data.
It really seems like the jurisdictional walls around the world are just getting higher and higher. What about future diplomatic agreements? Is there any actual hope for peace between the U.S. and the EU on this?
Well, there is the EU-US Data Privacy Framework, which finally replaced Privacy Shield. But that is strictly for standard commercial transfers. It does absolutely nothing to solve the law enforcement and national security issue we were talking about today. The real hope, the actual light at the end of the tunnel, is the EU-US e-evidence agreement.
An e-evidence agreement, how would that work?
Negotiations have been ongoing for a while now. The ultimate goal is to create a sort of ML-Lite, a legally binding, streamlined way for U.S. law enforcement to rapidly request data that still fundamentally respects EU judicial rights and oversight, without the agonizing 10-month wait of a traditional diplomatic treaty. But, realistically, we are still a long way from that being finalized and tested in court.
So, until we get there, we are stuck in this very messy, very dangerous middle ground. Well, let's try to summarize this entire deep dive into actionable takeaways for our intermediate professionals listening. We have covered a massive amount of ground today. If I'm that GRC analyst or cloud architect, what are my concrete action items for when I log in tomorrow morning?
I would boil it down to 4 critical steps. Number 1, map your data. You cannot protect what you don't know you have. You need to know exactly what data is sitting in your environment that is subject to Article 48. Not all data is created equal. Is it basic HR data or highly sensitive customer health data? You need to map your radioactive risk zones.
Okay, data mapping is step 1. What is step 2?
Step 2, review your Article 28 contracts. Do not just blindly sign the standard DPA from your vendor. Look very closely for specific legal clauses about challenging foreign warrants. Does your cloud vendor have a documented policy to legally challenge comedy issues in U.S. courts? Will they explicitly promise to notify you if they receive a warrant, assuming they aren't bound by a strict gag order?
Step 3.
Step 3 is the risk assessment. Specifically, you need to execute a formal transfer impact assessment, or a TIA.
Can you walk us through a TIA? What does that document actually look like in practice for an auditor?
It is a highly detailed formal document where you, as the customer, evaluate the specific legal risks of the destination country, in this case, the United States. You have to formally write down the answer to the question: does the U.S. have surveillance laws that impinge on fundamental EU rights? The answer is unfortunately yes, due to the Cloud Act and things like FISA Section 702. Then you have to ask, what specific supplementary safeguards are we putting in place to mitigate that risk? If your answer on the TIA is just standard AES encryption, you fail the assessment. But if your documented answer is HYOK, or we mathematically retain the keys in Europe, you might actually pass.
And this TIA document essentially becomes your primary legal shield.
Exactly. If you get audited, or worse, if you get breached or fined, this document is your absolute primary defense to lower that massive Tier 2 fine. You can point to it and tell the regulator, look, we didn't just ignore this. We thought about it deeply, we thoroughly analyzed the risk, and we implemented strong technical mitigations. It proves the principle of accountability that we talked about at the very beginning of the show.
And what is the final step, step 4?
Step 4 is architecture. You have to design for the law, not just for uptime. If the data is truly existentially sensitive, you must keep the cryptographic keys yourself using HYOK. Or you need to seriously consider using a purely European-owned cloud provider. There are plenty of really good ones out there, providers like OVH Cloud or Exascale or T-Systems, providers that simply aren't subject to the extraterritorial reach of the U.S. Cloud Act because they simply do not have a U.S. parent company.
It really sounds like it's time for a very uncomfortable but very real conversation with your cloud vendor. When was the last time you, as a customer, asked your hyperscale provider specifically, what is your exact operational playbook for a Cloud Act warrant? Not just the generic marketing question of, are you GDPR compliant, but what exactly do your engineers do when the DOJ calls your Seattle office at midnight?
Their answer to that specific question will tell you absolutely everything you need to know about your real risk posture.
This has been a truly massive deep dive. We've gone from the core ethical pillars of the GDPR through the hard, unforgiving reality of U.S. federal warrants, all the way to the terrifying math of European fines and the trade-offs of encryption. As we finally wrap this up, what is the final provocative thought you want to leave our listeners to mull over?
I think we really have to accept that the golden era of the borderless internet is completely over. For decades, we used to think of the internet and the cloud as this open, ethereal global space where data just flowed like water. But we are rapidly entering a period of severe technological balkanization. Digital sovereignty isn't just a political buzzword anymore. It is the absolute new reality of infrastructure engineering. And here is the thought to take away soon. It won't just be about where you store the data. We might see a future where data sovereignty dictates the actual physical network routes your packets take across undersea cables, just to avoid transiting through hostile legal jurisdictions. Your cloud architecture must now respect imaginary legal borders just as strictly as it respects physical latency zones. If you only design for performance and completely ignore jurisdiction, you are building a massive legal time bomb in the center of your enterprise.
A legal time bomb, waiting to go off at 3 a.m. That is an incredibly sobering thought to end on, but a necessary one.
It is, but it's the reality of the landscape we have to secure now.
Thanks for tuning into InfoSec Bytes. Keep exploring our 100 plus episodes on information security, AI, cloud, quantum, and cybersecurity incident root cause analysis. Please like, subscribe. We are on various platforms: Spotify, Apple Podcasts, YouTube, Amazon Music, and share to stay connected and keep your cyber defenses strong. See you in the next episode. Stay tuned.